Hi, I'm Judge Bill Henderson, Family Court Judge. I'm going to be discussing courtroom decorum and behavior. The courtroom at family court is not like television court. This is not a free-for-all where relatives and friends sit behind you, nodding their head, whispering in an effort to influence the judge in your favor. That behavior is, in fact, distracting and discourteous to the court and the audience, and will have an adverse influence on the court if they witness family members gasping, rolling their eyes, grimacing, smiling. Also, the only time usually a judge hears from witnesses is at an evidentiary hearing or trial. So please do not bring your witnesses to court with you for any other proceeding unless you have been ordered and directed to do so by the judge or your attorney has advised you to bring such witnesses to court. There is a specific order as to who speaks to the judge first. The person who filed the motion, the moving party, argues their case first unless the court indicates a different order or is ready to make a decision without a hearing or argument based on the papers that are submitted. Generally, the person who filed the motion speaks first. And while they are speaking, you should sit quietly, take notes on things you want to correct or that you want to address to the court or have your attorney address. And then in addition to the argument you want to make, you can add in those items that you took notes on while you were sitting there. You should be prepared to tell the judge exactly what you want, even if it's not in your papers. Because sometimes things change between people from the time the papers are filed and the time you're in court. So telling the judge what you want, it's important for you not to just concentrate on the paperwork, but the items which have occurred since the paperwork was filed. Also, if you have exhibits or documents that you think are important, now is the time to direct the court to those exhibits by referencing the Bates stamp. That's the number in the lower right-hand corner of the papers and documents on the exhibit, telling the judge why they are important. The responding party, the non-moving party, is then permitted to respond to what you have argued, and the judge will then rule. Sometimes the judge will have questions. Be prepared for that. It is appropriate to stand when you are addressing the court and to be polite and answer the question that's asked, not add additional material. If the judge believes it is necessary, you will then be sworn in by the clerk of the court. You will raise your right hand to be read the oath, asking if you swear to tell the truth. You need to answer audibly yes or no, as the case may be, for the official video record. It is not appropriate at this point or any point to call the other side a liar, a thief, a molester, a criminal, or any other adjective that you may very well believe to be true. No name calling. Your judge can only act on proof. A copy of certified court minutes of a criminal proceeding, a transcript where admissions of thievery were made, findings in another court establishing bad acts, etc. So unless you can prove what you believe, leave the drama at home. But if you have those documents that are referenced to back up what you're saying, please bring those to court. If you have such proof and it is relevant to the issues that are actually before the judge, then make certain that they are filed as exhibits well before your court date and that you have a set of your exhibits delivered to the other side or the lawyer. That way you'll have the right to argue them at the time of the hearing. And you won't catch the judge and everyone all caught off guard, unprepared and surprised. If you can in fact prove allegations that are relevant to your case, then you will be asking for an evidentiary hearing or trial, at which time you will put on your proof. You will call witnesses to the stand, introduce evidence from which the court can then make rulings in your favor if you have proved your case. To get to an evidentiary hearing or trial, you must provide sufficient proof in your pleadings for the court to find adequate cause for an evidentiary hearing. These are technical issues for which you should consult an attorney if at all possible. If you bring matters before a court and cause the other side to incur attorney fees, without sufficient proof to support your position, you may very well end up with an order that you have to reimburse the other side's attorney fees. Therefore, it is prudent and wise to consult with an attorney on technical legal issues that go to the heart of your case so it can be decided whether you have sufficient proof beforehand. Because if you don't have sufficient proof or documentation, as mentioned, you not only may lose your motion, you may have to reimburse the other side's attorney fees. So we hope some of this information is helpful, and please consult this video and the others available from the other judges. Thank you so much.